In 2015, in a decision known as Obergefell versus Hodges, the United States Supreme Court held that the marriage licensing laws in Kentucky, Michigan, and Ohio were, quote, invalid to the extent they exclude same-sex couples from civil marriage on the same terms and conditions as opposite-sex couples, end quote. I'll be asking you a few questions related to this, but to be fair, I want to call your attention to some things you need to know. First, notice that the court did not hold that Tennessee's marriage licensing laws were invalid. Tennessee's licensing laws were not part of that decision. In fact, no county clerk who issues marriage licenses has ever been sued. Those who believe in judicial supremacy would say, that doesn't matter. Even though no county clerk was ever sued in regard to the constitutionality of the license statute they administer, they must disregard the language in that statute that says they can only issue licenses to, quote, male and female contracting parties, end quote. Second, the right to marry only related to civil marriage, meaning marriage is created and authorized by civil law, or what we would call legislation. So the right in Obergefell was for a right to a government-licensed marriage. Third, another U.S. Supreme Court decision, Meister versus Moore, which has never been overruled, says that there is a right to marry under the common law. Common law is an unwritten form of law that derives its force from natural law, history, and tradition, and not from legislative enactments or judicial rulings. It is pre-political law. In the Meister decision, the Supreme Court said that the right to marry at common law is not conferred by the government. It is inherent in and arises from the fact that we have been made male and female. Fourth, the Obergefell decision did not say that marriage between a man and a woman at common law, a non-government licensed marriage, was unconstitutional. It did not overrule Meister versus Moore. Fifth, Tennessee only allows licensed marriages, but if the licensing statutes were repealed, then a man and a woman could marry at common law, consistent with the way the Supreme Court described marriage in Meister versus Moore. Sixth, nothing in the U.S. Constitution requires states to license marriages. Nothing. Seventh, and lastly, a provision in Tennessee's Constitution that no court has ever held unconstitutional says, quote, any policy or law or judicial interpretation purporting to define marriage as anything other than the historical institution and legal contract between one man and one woman is contrary to the public policy of this state and shall be void and unenforceable in Tennessee, end quote. Now you know enough to answer some fundamental questions about what you believe and your views about the separation of powers and federalism as it relates to marriage.